All right, Melissa Paez. Norma, on this case, it's set for sentencing. State, this is Melissa Paez. It's set for sentencing, but defense counsel is out of county on another matter. So is everyone okay? It's an opposed offer. I don't know. Did you all have witnesses?
If we're not opposed to it, if you want to accept for that, it's not.
Okay. All right. So we won't be able to do it on Friday because I have a mental health docket.
Okay.
So if you can speak with Miss Ferguson and you all come up with a date. So we're just trying to get a date for your attorney to be here, okay?
Okay.
So if you'll confer with her and then let me know what date y'all have decided on.
Yes, ma'am. All right. Thank you, Judge.
Thank you. Jamison Franklin.
Your former. It used to be my guy. He upgraded SE. Can I have one more?
Court is calling 2025 CR 004-587 State versus Jamison Franklin. Could I have parties announced?
And Jonathan Alvarado for the defense.
And are you Mr. Franklin?
Yes, ma'am.
All right, did you review the document entitled Motion to Revoke Community Supervision and First Amendment Motion to Revoke Community Supervision with your attorney? And did you understand it?
Okay. So, Judge, I apologize. I have not gone over the First Amendment with him. Just kind of show it to it real quick.
Okay. All right. So, Mr. Franklin, did you have a chance to review the motion to revoke community supervision and First Amendment motion to revoke community supervision with your attorney?
Yes, yes.
And did you understand it?
Yes.
Are you the same Jamison Franklin who was placed on community supervision for the offense of manufacturing delivery of a controlled substance, penalty group 1, 4 to 200 grams on July 24th, 2025 for a term of 8 years? Is that you?
Yes.
All right, state.
On state's first amended violated condition number 1 on or about the 3rd day of December 2025 in Bear County, Texas, the defendant Jamison Robert Franklin committed the offense of possession of controlled substance or violation of condition number 1.
How do you plead to that? True or not true?
Not true.
Violated.
Well, I mean, if he's pleading not true, today is supposed to be set for a contested. Are you all?
So,
Do you want to?
I apologize, Judge. I didn't know exactly what the court wanted to do today because this is actually a First Amendment we were just handed today. These are new offenses that happened. I think the offense date is on either Monday or Tuesday of this week. And so I was going to ask the court for a reset at this point because of the new allegations. Additionally, Judge, I was not appointed onto the new cases. So I do not have the discovery as of yet.
So from the allegation that's not the amended motion, but the original motion, the allegation of possession dated from December 3rd, 2025, you don't have discovery on that?
No, Judge, I do have discovery on that. I am the attorney appointed on that case. I would just ask for a reset, Judge, because at this point with the new offenses, I think it would be, for all parties and the court, it might not be efficient to try and proceed with those cases, the MTR today, when potentially we could wrap all the cases together. And I've conferred with the state on this, and that was kind of our approach to it, Judge.
So when is that going to be accomplished, if that is accomplished?
Well, I would need to get on the new cases or get the discovery in the new cases. So as soon as that could be done, Judge.
And are the labs in for the?
So, no, Judge, and the types of charges that the new cases are, we would not be able to proceed on the drug at this time because the turnaround for the testing, but there are 2 other cases that would potentially be able to be proceeding with the.
All right, and the other 2 cases,
It's a theft and a fraud use.
do you have discovery on those?
I do not.
All right, so he needs to have discovery on those. And Norma?
Yes.
This will be the last reset for this case. Set this for a contested hearing in 3 weeks.
Okay.
March 19th? Okay.
Okay. Thank you, Judge.
You're welcome.
Sorry for the confusion.
Oh, no problem. Bashan, Franklin is being reset for March 19th.
Yes, ma'am.
And that will be a contested or a plea of true. I don't know.
Thank you, Judge.
You're welcome. Mr. Blanc, are you ready on your case?
Yes, Judge, we're ready.
And who is your client?
Eric Cepeda.
Thank you. All right, so today we're set for motions and also for discovery. First off, are there any motions? Well, have you all had a chance to confer on motions and see if there's motions that you all can agree to? And if you all can do that, I'm going to ask that you all do that off docket. I think it'll be more
We
efficient.
will.
And then whatever you can't agree on, just let
We'll
the
come
court
back.
know.
Yes, Judge.
All right, and then the other thing, counsel, are there any discovery matters or anything that needs to be exchanged?
Yes, Judge, we have some information we want to exchange with the state. We believe it will be mitigating and very helpful for the state and something we want them to have before they consider their final plea bargain offer. So we'd like to have one more time for final discovery if that setting is possible.
All right, and then state, do you have any objections to any for another discovery setting?
Just for your notes, I know at the last setting, the state informed the court that we were still outstanding DNA, but that has recently, like within the last week, been turned over to defense.
Okay. And then counsel, I know you all will want to review the DNA with your
Yes,
client.
please.
All right, so how much time do y'all need? 45?
That's 45, 60, whatever.
Oh, see, Charles always throws in the last day. But I will tell you, I was thinking of 60 because that'll give you guys because based upon the discovery settings that we've had and the number of co-defendants, this case is complicated.
This dump got returned over, so I would describe the discovery as the linear stretch.
All right, so then I won't put it as a final discovery, but we're getting close to final discovery, guys.
Yes.
So I will put it for a 60-day reset for you all to get that together and just make sure that you all go over motions too.
We will. Thank you, Judge.
All right, Ms. Ferguson, what date? April 27th. 27th?
That's fine with me.
Okay. Then, State, have you had a chance to review the defense's motion? Are we proceeding on this motion to alter conditions of bond? Or is this something different?
It might be old, Your Honor, or something you've already acted on.
Oh, okay.
Mayor, what's it down there?
Yes.
Thank you.
I think.
The judge, this isn't old. This is from November, or this is Thanksgiving. This was a Thanksgiving deal, so we're good.
All right.
Thank you.
Yeah. No problem. I'm glad you're on it. All right, thanks, guys. All right, and Charles, they say you have someone else on
I
the.
have several more, but the next one is Urabas, Maricela Urabas.
All right, and have you ready to proceed on that?
We are going, yeah, we're going to ask for, the state's asking for a reset, so we're ready to proceed.
All right, could you have your client come up?
Yes, ma'am.
Oh. All right, then it's you, Mr. Bond. No, it's family violence. All right, what is happening on this case with discovery? Or what
There
do they
is
need to
a-
reset?
The state, we reset it last time for the state to talk to a witness. I've been informed they spoke to the witness, but not enough to make a decision. So they'd like a brief amount of time to finish that discussion
All right, 3 weeks.
at the most. I was thinking 2 weeks.
All right, Ms. Ferguson, I need a 2-week reset on your ribis. I'm sorry, Judge. A 2-week reset?
Yeah, I got to file the motion. The state's talking to her right now. And we're going to be filing a motion, Judge, to change her no contact to no harmful or injurious. The state is with the complainant right now.
Okay. March 12th.
Okay, March 12th.
Yes,
Okay,
all right, once you sign the reset form, you'll be excused. Thank you.
I'll bring it to you right now.
And Norma, that's for the state to, they're speaking with the complainant, but also for them to tender an offer. DeAndre Coleman?
Well. Get back to you on that. So, is this okay? I don't know. We don't really go over the last one. Yes, sir.
Okay. All right, you want to step back? Need to go over things?
I'm sorry. So you want to talk to me further about signing this, or you want to talk to the judge about the next part? It's up to you. I would like to talk to Mrs. Boyd about the next part. Okay.
Okay, talk to me concerning what?
The certification of right of appeal, we're going to ask for a contested motion to revoke.
Mhm.
My client understands he's going to plead not true to the allegation, one of the allegations. But it's about signing the child court certification of right of appeal. I've circled it's not a plea bargain case. He still does have.
Here's the thing. I would love for attorneys not to check boxes because I decide whether he can appeal or not. And I don't know what I will do in this case. And I don't know if y'all have reached an agreement whether or not he would waive his right to appeal. So I'm in charge of checking boxes. So if y'all could tell attorneys on trial court certification, please do not check boxes because then I have to scratch things out. So now, with regards to the motion to revoke, this is what I'm going to explain to you. This is a contract with the court. If you want a contested hearing, what that means is the state, whatever allegations they're saying that you did or whatever rules they're saying you violated, they'll have to bring in witnesses to prove it. Do you understand?
Yes, sir.
All right. So do you want a contested hearing?
For the harassment allegations, yes, ma'am.
All right. So the only thing that I have in the,
Trespass, I apologize.
yeah, the only thing I have in the motion to revoke is an allegation that you committed a criminal trespass and the use of marijuana. Those are the only two things I have.
Yes, ma'am.
Okay.
Excuse me, Ms. Roy, is it possible to only contest one of those?
That can be up to your attorney if that's what you want to do. Yes, you can plead true or not true to whichever allegations you want to plead true to.
Yes, ma'am.
All right. So let me ask you all this.
Yes, sure.
What is the plans for, what is the recommendation?
Recommendation from the states to revoke the law.
All right. And so I only have two allegations, criminal trespass
Well,
and marijuana.
there's gonna be an amended one coming. I need to be in completion because there's gonna be two number ones added to the MTR for those things.
All right. And in the amended allegations, what are the allegations?
Two charges of harassment.
Okay. So then what we'll need to do is number one, is that going to be filed today?
I need supervision as soon as I can tell you so they can on there and get the amended.
All right. So they're telling me that they're going to amend the motion to revoke. So what that means is they're saying they're going to add more allegations other than the criminal trespass and the marijuana. They're telling me they're going to add 2 allegations of harassment. I don't know anything about these allegations. I won't know until somebody presents some evidence to me if they do so. But in regards to motions to revoke, you can plead true or not true to any allegation you want to.
Yes.
So that means you don't have to plead true to everything. You don't have to plead not true to everything. It's really up to you, hopefully after the discussion with your attorney. All right, so what I'm going to do, I'm going to reset it. And I'm going to reset it. It's going to be reset for a contested. If it turns out you've spoken to your attorney and you decide not to contest, your attorney, I'm going to ask that you let probation know because they'll have to have witnesses here. And does everyone want the witnesses in person?
Yes, sir.
All right. So, Ms. Ferguson, can you set this for a contested hearing? And what we'll set it for, we'll set it in 3 weeks. And so that'll give your attorney 10 days, well, more than 10 days.
March 19th.
Yes.
All right. So March 19th is going to be your contested hearing.
Yes, ma'am. Judge Boyd, while I have you, can I ask a question?
Sure. Now, whether I'm allowed to answer that or not depends on what the question is.
If I wasn't informed that further contact would lead to harassment, are those amendments to the?
Okay, so this is what I'm going to tell you. Because you're asking me about the allegations in the motion,
Yes.
I'm not allowed to give you the law on that.
Okay.
You have to speak to your attorney because once I start commenting, because it sounds like you're trying to raise some sort of defense to me. And if no, the question you're actually asking me is sort of a defense. And that's, if I answer your question, I'll be commenting on the evidence and that makes make it seem like I'm not being objective and open. So that's a question you'll have to ask your attorney. So any legal questions of that nature, be sure to talk to your attorney about it and he'll give you the law on it, okay? All right, any other questions?
No, thank you, Judge Boyd.
You're welcome. So we'll see you back on March 19th. That'll be a contested hearing. If you discuss things with your attorney and you decide not to have a contested hearing, he'll let probation know so they don't have witnesses.
Love your flowers.
Oh, thank you.
Yes, ma'am.
They brighten the room. I think so.